Mesan so Emma Obi Biara Akwaba Bim Ediba in Tanakasi, a subsia, in some echoes, Messel no subscribe no like no share video so at the Amawina no so be Ashana Bibiano, and the Belcos organize the Webro now so the Onya Bina or the usual Mabusia in summer Ababeto a Janity Amo Edi.
And I indicated clearly what yesterday's proceedings were about. It was a notice to appear, NTA hearing, and that is on the back of 10 having been picked up by ICE and placed in the detention facility, ostensibly for the reasons that he had overstayed his visa period in the United States. I had also communicated to you that before he was picked up, he had put in a petition or an application for an adjustment of his immigration status.
Yeah.
At that point, once you have been lawfully picked up, you have to be given a hearing in the immigration court. And that was what happened yesterday. And we all have at least gotten an indication that Judge David Gaddy adjourned the proceedings to the 27th of April. What happened yesterday was just simple. Ken, as it were, through his lawyers, had to give reason why he should continue to remain in the United States, or vice versa, why he should not be deported, because people are saying he has been classified as illegal citizen. So that was what happened. And the matter stands again to the 27th of April. But something also happened yesterday, maybe which was not put to the public domain. There was a bond posting, a bond application hearing. A bond posting or bond application hearing is the United States legal parliament. In our jurisdiction or jurisprudence here, we say bail application. Now, we posted the bond, and just as the court was about to make a determination, our government authorities raised an objection that there was an extradition proceeding pending. Now, proof immediately could not be provided to the presiding judge as to the pendency of the extradition proceeding. On that score, the judge adjourned the proceedings for the bond posting to the 19th of February. Our authorities have 30 working days to provide ample proof of extradition proceedings to the judge, failing which the judge will make a determination or a decision one way or the other to release Ken from detention custody and admit him to his freedom temporarily. Now, in considering all this, there are three factors which influence the decision. Whether or not Ken is going to be a flight risk after his removal from detention, whether he's going to pose a danger to the community, or whether he's able, ready, prepared, and willing to post the bond in the amount specified. So that is where we are. 30 working days, failing which the bail application would be the bond posting or bail application is considered. So that request was temporarily denied. The main hearing, the main ICE hearing, which commenced yesterday, stands again to the 27th of April.
Oh, okay. Okay. So it means that there are two things. 19th February for the bond application hearing to be heard. Okay.
And then 27th of April for the continuation of the NTA hearing.
Okay. Okay. All right. I guess he's well this morning after what happened in court yesterday.
Oh, at least until the link was disabled, you saw Kenneth. I keep on telling you that the good Lord Almighty God continues to keep and preserve all of us, including you, Ken, and I. So he's well. He's well. He's well. No matter what the circumstances he's found himself in. You know, even if it's right, he's well.
What was the link being put down at the request of the lawyers of Ken?
Let me throw this education into the public domain before it is lost on all of us.
Yeah.
I think I either spoke to you or Faustina, one of you, that there are two scenarios. It's either a public hearing, a private hearing, or what we also call a closed hearing. So it's up to the judge to make that determination. Yes, the Kenneth lawyers put in application for a private hearing because they were releasing the position that there were certain sensitive matters that were not supposed to be in the domain. Be that as it may, there is an immigration court practice manual which guides everyone who has served the link yesterday. All right? And there is a veritable caveat in that practice manual that the proceedings in the courtroom cannot be subjected to any video, photographic, electronic, or other similar devices for the purposes of transmission or circulation of the proceedings in court. This caveat is meant to guard courtroom decorum. All right? And anyone who attempts to go to the link, in legal parlance, it's called the lobby. Those who were granted up were bound by the courtroom practice manual to observe the proceedings and not to attempt to circulate them through viral attention. Just as was egregiously abused last week. And that might have also occasioned the disabling of the list. Now, this practice manual is to guide all those who have access to the proceedings and to attempt to circulate or transmit them was going to compromise courtroom proceedings and decorum and undermine the very integrity of the administrative process. Because in all of it, the paramount privacy, or as Americans would say, the privacy and interest of the accused person of interest or suspect was at play. So if that also influenced the disabling, I'm unable to say it, but I'm saying that this is what guides what happened yesterday. But yesterday, there was, with greatest of respect, a semblance of journalistic jingoism, where every media outlet was trying to accusate one another as to who was going to transmit or circulate the proceedings first. This was not tenable. So I would urge that we also offer ourselves some little education when we get involved with these matters. I must say that in this jurisdiction, in Ghana, you are permitted or allowed as a to go to court and view proceedings. You know that, for example, you don't know.